Thank you. Srimati Maneka Gandhi.
Sir, environmental crimes are the most serious crimes in the world, not only because they hurt you immediately, but they hurt all generations to come. Mining, poisoning the rivers for gold panning, throwing sewage into water, opening polluting industries in the wrong places, as Supriya Sule just said, ignoring the current laws, whether from big brick kilns to chemical factories, damming rivers just to give money to contractors, allowing inappropriate factories near forests, inappropriate hotels outside sanctuary areas, allowing the sale of polluting consumer goods like firecrackers, or the export of leather and minerals, or the sale of flooring materials that clearly come from destroying hill ranges like the Aravalis. These are genocidal crimes, no less than war upon the whole of India. To treat them so lightly as civil issues rather than criminal ones and allow the polluter to pay his way, probably from the same money that he has earned by polluting the area, is cynical. It shows collusion. Before I start, I'm going to talk about the minister. The minister is like rain upon the desert, as I've said before. We have waited 20 years for a good minister, and he and I share the same values. We have had 20 years of contractor-driven ministers, or ministers who didn't understand what the hell they were doing. To have a person who uses his brains, which is just common sense, is like manna on the desert. However, Jairam and I share most values. The only difference between us is that I am so passionate about India that I want everything done today, yesterday. And Jairam wears his passion like a cloak, which he takes off and puts on when he changes ministries. I would urge him that he could be the best minister in the entire cabinet. He is in a very ticklish position. If he is good at his job, he has the contractor-driven lobby baying for his head for more dams, more roads, more cutting, more encroachment, more killing. And if he's bad at his job, he has the whole of India to spit on him, as they have in the previous 20 years. He has generations of children who will remember him as the bogeyman. So he is stuck between a rock and a hard place. In this case, he needs to wear his passion and to do things quickly. This tribunal does not really reflect the person that Jairam is. And I'm going to point out a few things which could make it better. None of these things that I propose have come from my mind. They are the nichor of 40, 50 environmental study groups that have put themselves together to see what is wrong with the bill and what can make it better. We have had two absolutely stupid bills before this on the same lines, which never ever matured into anything. We need to have one good bill. The National Green Tribunal Bill 2009 that would judge environmental issues was introduced on 31st July 2009. There is this feeling that it was done for the establishment of a National Green Tribunal for the effective and expeditious disposal of cases relating to environmental protection and conservation of forests and other natural resources, but it will have the same powers as a civil court. It will subsume various state-level authorities that address environmental issues, as well as committees created by the Supreme Court for that purpose. It comes in response to the 186th Report of Law Commission of India on the proposal to constitute under the NEAA Act 1997 for the limited purpose of providing a forum to review administrative decisions on environment. Unfortunately, the implemented NEAAs have remained dysfunctional, as no judicial member has been appointed since 2000. Now, if the minister really wanted, he could have made these tribunals work, because it is the executive who has made them fully inoperative. Instead, this new bill that he is bringing in is flawed in parts. The National Environment Tribunal Act, which is the legislation, has yet to be notified after 8 years. Since it was enacted by Parliament, it has yet to be, the tribunal under the Act is yet to be constituted. So these two tribunals are non-functional, remain on paper. In which case, this is an important bill. 1 second. If it had been conceptualized, just give me a second. If it had been conceptualized to provide safeguards to the poorest of poor communities in the face of a rapacious attack on their resources, it might have been approached differently. But it seems to be yet another mechanism to give jobs to bureaucrats. Now, I would take it one by one. Some of the amendments have already been made by the minister. Some of them seem simply cosmetic, like changing 1 year to 2 years. And 3 of them seem all right. I would recommend the following. The appointment of experts. The intent of most appointed bodies can be judged from its composition. And on that score, the bill fares poorly. The proposed composition of the tribunal follows a tried, tested, and failed track. Anybody who's read the bill is bound to wonder, as did all the NGOs, whether it's meant to be a club for retired IAS officers and technocrats. As it stands, the expert members of the tribunal would need, in inverted commas I say, administrative experience of 15 years, including 5 years' experience in dealing with environmental matters in the central or state government, or in a reputed national or state level institution. This is an undisguised code for the Jobs for the Boys program that all senior retired bureaucrats join. What prevents, for instance, if I wanted a job on the tribunal, I don't have any of these administrative experiences. What prevents Rajendra Singh or Medha Patkar or people who have actually done a huge amount of work in protection? They cannot join the tribunal even though they have the experience, because they don't have, and even though they have the passion. After all, Supreme Court judges are not born knowing the law. What they do sitting on the Supreme Court is to have an eye for truth, an eye for justice, and common sense, which is what anybody working on the ground has. But you have excluded us from this by saying administrative experience of 15 years, 5 years experience in dealing with environmental matters in the central or state government. What would you count as experience? Bureaucrats are changed every 3 years. They really are not either learned or educated in anything they do. It's simply a matter of passing files around. Why not give an appointment or the ability to be appointment, the window of opportunity to people who have actually worked? All earlier attempts in handling the environmental problems through the NEAA and other bodies have failed because their control was left in the hands of bureaucrats. Had such appointees been competent, those government departments or institutions where they served would surely have been instrumental in protecting the environment, which is clearly not the case, which is why you need a tribunal. In fact, it is the colossal failure of administration that has created the compelling logic of the tribunal. What would be infinitely better is for the tribunal expert members to be of technical and scientific background, experts in public health, occupational health, social science, with relevant experience in environmental and occupational health, or with qualifications for its membership. There is no provision in this bill for ecologists, environmentalists, hydrologists, and anybody from civil society or NGOs who have been active in the field of environment to become a member. This should be changed. Moreover, a tribunal member can join a corporate house whose case he might have dealt with within 2 years of demitting office. You've changed from 1 year to 2 years. It's a dangerous proposition that harms transparency and impedes tribunal independence. The House panel feels that judges shouldn't be allowed to take up directorship of any concern or be associated with any industrial house. Even worse, the shortlisting of candidates will be done by the Ministry of Environment and Forests. We know the kind of pressure that is put on them to select weak or vicious people with no integrity or value, either irrelevant retired bureaucrats or technocrats in search of re-employment. This is what should be amended. A, there should be a transparent process of appointment of members and chairmen. There should be a noted environmental lawyer or jurist as a member. No bureaucrats as expert members. In fact, a specific clause that anyone working in MOEF or any ministry whose decisions are subject matter before the court cannot be included. If we need these great experts, they can be called in for advice. Supriya ji has talked about amicus curiae. They can be amicus curiae, no doubt. The word expert, as qualified by the bill, is dated. Science, engineering, technology, administrative experience is the only thing that makes you expert? How about people who have spent their lives in the field working with cold logic to get justice? The field should be open to anyone who has dealt with environmental matters in the field. As I said, I, for one, would like to be a member. What amendment can you put in to include people like me? Obviously, by including NGOs and civil society, wildlife scientists, ecologists, please amend this for the bill to have any meaning. Then we come into the second phase, which is restrictions on who can approach the tribunal. Now, there is an amendment here, and it's a good amendment. It says that any person aggrieved, including any representative body, can file an application. What it was before was judicial and quasi-judicial organizations, institutions cannot be strong if only a few people conveniently selected by the authorities are allowed to approach them. Moreover, since the courts have recognized that since environment falls within the purview of Article 21, it is clear that all persons have a duty to protect the environment and a corresponding right to question the adverse impact on environmental health. The bill ignores this principle. In chapters 14 to 16, the tribunal is only allowed jurisdiction in those cases considered substantial. And this word substantial says has been qualified to mean the community at large rather than an individual or a group of individuals, and that the damage should be grave. This is an extremely serious error. The tribunal judges what is substantial without any qualification. When does a group of individuals become a community? Would 50 remaining Jarawa tribals qualify as a community or as a group of individuals when their forests are cut down by loggers? Does the individual not deserve protection, or does he have to wait until everyone suffers as much as him? Leaving the judging of the issue to the tribunal to decide whether the group is large enough or the issue is grave enough is ridiculous. Let us suppose I live in a lane of 6 houses, which has 3 peepal trees, and one company comes and cuts them down. This would seem so small to the tribunal, but it is life and death to that lane. Also, much of the pollution is non-point and has so many sources. So these words, substantial, grave, broadly measurable, should be removed. What should the bill add? All issues rising out of non-implementation or compliance of approval conditions should be a subject of the bill. This is one of the main grievances, as you have with all the mining cases that you've taken action on. They take the approvals for a small patch of land and destroy an entire district, as in Karnataka, Andhra, Rajasthan. You have no compliance mechanisms. Why not make this bill one of your instruments? Why is the bill in clause 15 restricting itself to just providing compensation and perhaps restitution of property? Does this make sense? After the companies have finished mining, the tribals will get some money from them and black empty holes in the ground laid waste as restitution. The bill has cut off prospective activity, which includes environmental damage. An amendment is needed here to include prospective damage rather than simply retrospective jurisdiction. Has the ministry not heard of the word precautionary principle? Obviously it has, because that is one of the amendments that it has brought in, and that's well done. But prevention of pollution is the most important way to protect the country. The ministry has protected itself by refusing to give the tribunal teeth to challenge its decisions. While I'm fairly sure that there would be very little need to challenge Jairam's decisions, we have had secretaries like Ghosh and ministers like Balu and Raja and Meena and Kamalnath who march to different drummers. Therefore, the bill should be amended to give it powers to review a statutory authority's exercise of judgment. The courts are subject to review of their decisions. Why not a ministry or an expert appraisal committee? Bring in amendment for review of abuse. I'm going to take 10 minutes more. For review of abuse of authority or failure of application of mine. Then you will see that government clearances will survive vested interests. According to clause 15, the tribunal can give compensation to the victim, but it cannot quash the approval granted. Is that right? What does this mean? So I can keep giving money in the air notionally to the forest dweller, but I cannot stop the mining license? In which case, what is the point of the bill? On one hand, the bill can give compensation to individuals. On the other hand, it prevents them from approaching the tribunal before the license is made pakka. So basically, this bill is neither fish nor fowl and will help polluters carry on as business while giving money to their victims. Either the drafting is poor, or this is a deliberate attempt to make something useless again. Has the bill got any real power?
कृपया समाप्त करें, आपका समय खत्म हो गया.
Ji? I'm afraid you'll have to give me some time, sir, because this is really important.
ठीक है.
मैं 10 मिनट लूंगी.
10 मिनट नहीं,
मैं माफी चाहती हूँ कि मैं एक्सीड कर रही हूँ,
सिर्फ
लेकिन ये
5
बहुत इंपॉर्टेंट है।
सिर्फ 5 मिनट, 5 मिनट में खत्म करना ठीक है, उसमें कोई खराब थोड़ी बोल रहा है।
Has the bill got any real power? The proposed enactment does not have the power to stall any project that caused damage to the environment. It can act only when the damage is done by dealing with the origin of pollution. It also fails to hold delinquent polluting companies criminally liable for their acts of omission and commission, such as Bhopal's industrial disaster or any, God forbid, nuclear accident. One of the significant amendments proposed in the new draft is that decisions of the tribunal can be challenged in the Supreme Court. The earlier draft said that the tribunal's decisions would be final and binding. The amendments still do not address some core concerns. For instance, the bill is vague about tribunal's mandate and states it will deal, as I said before, with substantial questions. And that means it will only look at single point sources of pollution and not cases where there are multiple points. Should this tribunal not have the power to act for the protection and cancel environmental clearances if necessary, provide incentives to individuals who work as eyes and ears to nature and wildlife? Why should it penalize alert NGOs and civil society for raising their voice? Should it not have the power to issue contempt of court notices to polluting companies? Clause 18E is another bizarre clause which says that among the people who can file for relief, compensation or settlement is any representative body organization functioning in the field of environment. This is problematic. There is no reason why only an environmental organization can file appeals before the tribunal. Why not human rights organizations, public health organizations, labor groups, plaintiffs? Why should the permission of the tribunal be needed before applications are filed before it? This portion of the bill should simply be deleted before it heads inevitably towards a constitutional challenge in the Supreme Court. All Indians are affected by a pollution problem and when their rights are taken away. For instance, in Kutch, where companies have come and drilled deep wells in the ground, robbed hundreds of villages of their groundwater, is that not a human rights problem as much as an environment? If an authority takes away a forest and substitutes it with an iron ore company in Odisha, is that not a human rights problem? The rights of social organizations to approach the tribunal should be expanded because at the moment, the provisions are draconian. In 18E, a number of institutions need not be representative or even working in the field of environment and yet be concerned about environment and loss. This line has to be amended if justice is to be served. I want 3 minutes more. When can we approach the tribunal? Limiting the period of accountability. Section 14(3) of Chapters 3 in the bill deal with the tribunal's jurisdiction. It reads, no application for adjudication of dispute under this section shall be entertained by the tribunal unless it is made within a period of 6 months on the date to which the cause of action for such dispute rose. It is not clear why there should be such a restriction. Disputes can rise at any time. It's silly to expect that only those that rise in the first 6 months should be entertained by the tribunal. The bill is also silent on where it should take disputes that rise beyond this window time. If I miss the 6-month window, where should I go? Similarly, 15(3) says, no application of grant of any compensation or relief or restitution of property or environment under this section shall be entertained by the tribunal unless it is made within a period of 5 years from the date on which the cause of such compensation or relief first arose. The adverse effects of so many public health hazards, silicosis, asbestosis, radiation exposure, chemical exposure, for instance, take much more than 5 years to manifest themselves. Therefore, this fixed bonding or boundary of 5 years should be removed, or the bill should specify who will be liable for adverse effects discovered beyond this time limit. Where should the people of Bhopal go? Exactly. In Section 16, that deals with the appellate jurisdiction of the tribunal in the manner of any person aggrieved by orders or decisions of the Tribunal or National Biodiversity Authority or State Biodiversity Board under stipulated condition of the NTG bill. The person aggrieved can file an appeal between a period of 30 days from the date, which I think you've amended now to 60 days.
Please conclude.
I'm 1 page more, sir. 1 minute more. on which the order of the decision.
Yes, only.
This period of filing, I beg leave for another minute. The period of filing the appeal is too short and should be extended to 60 days, as often individuals are prevented by unavoidable situations from filing appeals within 30 days. So therefore, Clause 16 needs to be amended to remove or liberalize time frames. The last thing is an implicit threat to petitioners. Section 22 of 2 of the bill reads, where the tribunal holds that a claim is not maintainable or false and vexatious, the tribunal may make an order to award costs, including lost benefits due to any interim injunction. This provision, according to all the NGOs who have studied it, is very discouraging. In general, the courts always have a general right to impose costs of trials and other costs upon petitioners or the accused. This is taken for granted. There is no need to include this explicitly in Section 22(2) because it will deter people who are poor, concerned citizens from bringing in environmental issues before the tribunal, fearing the imposition of heavy costs in case their claim is disallowed. In any event, the correct way to tackle this is for the tribunal to decide whether prima facie the claim made by the petitioner is allowed before it, and whether any defendants have a fair amount of explaining to do. If this is done right in the beginning, there is no need for imposing any costs of trial or punitive costs at the end of the trial.
Please.
I would thank you for giving me this opportunity. I would like Mr. Jairam to bring in these amendments to make you and I on the same side. Long after we are gone, this tribunal might hold up to protect India and to take some of the pressure off to make environmental ministers honest and efficient. Otherwise, there is no other protection you will have except for this bill. I would urge you to accept these amendments, which are in the interests of India. Thank you.